So there have been a number of incidents, right, triggering oil pollution from installations. The most known are Deepwater Horizon from 2010 and Montara spill from the West Atlas rig in 2009, which had a transboundary effect of affecting not only Australia, but also Indonesia. And this may explain why Indonesia was the country bringing that subject back to the attention of the LEC IMO in 2009, 2010. We came back to the discussion whether we need an international regime for oil pollution from the offshore installations. We don't have any, right? There is, as we know, we will talk about that in details very soon. We have the CLC fund regime, which is quite successful for more than, how much is it? 50 years right now, covering compensating damages for more than 150 incidents, but it doesn't cover, it's not applicable to installations, and we will discuss that in a second in details. There is the Banker Convention and HMS, but there is no international convention on liability from offshore installations. So the IMOLEC had this discussion. The proposal came from Indonesia, and it was basically drafted in a way that it was modeled on CLC and fund convention. But there was a strong opposition to that attempt of IMO working on the liability from installations. The criticism centered around basically two arguments, and I'm not going to go into them. I have 2 pages of comments to that, but for the sake of time and for the sake of coffee break, we'll skip that. But mainly the criticism was that, unlike with ship source pollution, the pollution from the installation is rather national. It's rarely transboundary. It doesn't have that effect. And instead of ships which travel with the tankers, if you think about tankers, they travel around the world, and it has definitely a wider scope of possible damage, right? So this was the one argument, and the other argument was about the IMO mandate to regulate installation in terms of oil pollution, right? There were countries opposing to that. It reminds me a little bit this conversation that we have about mass, right? Talking about mass, Arif mentioned that yesterday or a few days ago. We had a similar discussion. So some delegations said like IMO in general doesn't have the mandate to deal with the oil pollution from installation. It did cover, UNCLOS talks about installations, and the IMO did cover in several instruments installations, but talking about prevention, right? So only in respect that the installation pollution affects navigation. And this is what those states said, that the IMO doesn't have a mandate to deal with liability, but only the effect of oil spill as it affects navigation. But I'm going to drop it here. I'm not going to go into details more. So right now we're going to transfer from London headquarters and look around the world. What is, if we don't have this international regime, what are the regulations? I'm not going to go through all of them. I'm going to cherry pick some of them to discuss in details. CLC and fund convention is not applicable, although there was one interesting case that I would like to discuss with you. The 1977 convention, which has a terribly long name. Maybe that was one of the reasons that it not became, it did not come into force from 1997. There were 2 drafts done by the CMI. CMI did a lot of work on that. The Rio draft and the Sydney draft, they presented the effect to the IMO, but then I think it was 2001, finally, IMO was not interested in picking up this subject. And we have regional solutions like the IMO directive, the European Union directive, the US OPA, Oil Pollution Act from 1990, applicable to installation. I would like to say a few words about that. And we have the industry, private arrangements where the industry takes over, makes a step, maybe a little bit with a view to prevent international regime to be introduced. We've seen that in oil pollution cases, CLC and Fund. There was Tovolop and Crystal, and now Stopia and Topia. We have them as well. There is this industry answer to the oil pollution as well, and limitation of liability convention. I promised I'm going to say a few words about that. Article 15, not applicable to offshore installations. So that was pretty quick. We have plenty of regional solutions. With the one that is of most interest to our Croatian, Albanian, Montenegrin, and Slovenian friends. But you will have to excuse me, I don't have time to talk in details about that.
Please do.
There is one peculiar thing that I learned from this regime. It actually talks about, for the first time, I think it was such a word, it talks about traditional damage. It is in the act, the word traditional damage. There is environmental damage and something what is called traditional damage. And they explain that it is, personal injury, the economic loss, but it's actually, it uses that term in the act. It's quite peculiar. Anyhow. PLC and Fund conventions. Why they are not applicable to oil pollution from installations. This is because of the definition of the ship. The CLC and Fund are applicable to oil pollution from ships, and the definition, as you see, is there. So basically the idea behind the CLC Fund was to cover liability for oil pollution from tankers, maybe oboes, but not offshore installations. There is the gray area. The gray area are floating offshore crafts known as FSUs or FPSOs. And this gray area was tried in a case from 2000, the Greek case called SLOPS case. And SLOPS was a waste reception facility which exploded in the Piraeus port. So a lot of damage. The companies that took the remedial measures and cleaned up the pollution went to the owner with the claim. I think he went bankrupt. So immediately they went with the claim to the Fund 1992. And Fund 1992 said, SLOPS is not a ship. We are not paying, right? We are not a piggy bank. We are not paying every claim. We have to be reasonable. This is not a ship. SLOPS was a former tanker, but it didn't have an engine. It was situated in one place, basically containing oil waste, and I think also processing the oil waste. But it could be moved on tow from one place to another. And the Fund said no, but the companies went to the Greek courts. And this case ended up in the Greek Supreme Court. There was the decision where the Greek Supreme Court, by majority of 70 against 5, I was looking for the English expression, 17 against 5, said, of course, SLOPS is a ship and the Fund should pay because it can carry the oil when on towage, and it brings this danger of huge oil pollution, right? So this was a case that probably is against the spirit of the CLC, and Fund was really, frightened is a bad word, but Fund decided to work on that. They had some opinion created, and the working group adopted guidelines, and those guidelines were adopted finally by the IMO. And those guidelines explain how we should interpret the idea of the ship under CLC and Fund conventions. And first of all, these guidelines contain like a list of ships which are most likely to be covered, and the list of ships which are not, well, the list of crafts, right, or vessels, we would say, which are not covered. by the CLC, but also the guidelines create something what is called the maritime transport chain concept. That is the idea of all activities starting from loading of oil to discharging oil in port installations. So all the ships that are involved in those operations are covered, but the other not. So generally, according to the guidelines, the slopes would not be a ship and should not be interpreted as being covered by the CLC fund. So this is what we have. I'm going to skip that convention. It never came into force. It was a convention adopted in London by a few European states, worked on that convention. It was not in force because of our main hero of today's stories, the limitation of liability. Because this convention wanted to introduce much higher levels of limitation of liability than 1976 limitation of liability, which was just adopted. So this was not acceptable for the states. And generally, this is why this convention never came into force. There is this slide about the Mediterranean Convention, but I'm going to skip that. A few words about Oil Pollution Act, because I really enjoy it. That's the first thing first. But then we could observe how those norms were actually practiced with the Deepwater Horizon. I did my research at Tulane in 2008 and 2009 for the OPA being applicable to ships. But then I came back to Poland and I actually could see how those norms are practiced with regards to installations. So OPA was a game changer. It brought so many, and this is something that you haven't heard. This is not the act that Professor Norman Martinez was referring to, right? He was referring to he was referring to Limitation of Liability Act. OPA is something totally different, right? OPA is an instrument which deals with oil pollution from ships, but also from installations. This is a national, you have to understand, this is a national instrument, so it could be more comprehensive. It doesn't deal only with sea oil pollution. It's applicable also to inland pollution as long as it is on navigable waters. It deals with oil carried as cargo, like CLC fund, but it also deals with bunker oil. So it's applicable to both, not as we have in the international regime. So the game changer was that, for example, the OPA 1990, first of all, quit with the common law bright line rule of no pure economic loss, right? OPA says that there can be claims which are so-called pure economic claims. What else did OPA change? A very broad concept of environmental damage, right? And also, it actually totally adopted a totally different philosophy when it comes to limitation of liability. Generally, under OPA, the general premise is that you have unlimited liability, because the test for breaking limitation of liability under OPA is so easily taken away, much more than even under LLA, right? The Limitation Liability Act, which we discussed recently. Okay, so when it comes to liability under OPA for spills from installations, the liable person is lessee or permittee of the area in which facility is located. They have a quite difficult term with regard to mobile offshore drilling units. They treat it, and this was the case in Deepwater Horizon, they treat it as a ship. So first the claims go to the ship owner, to the ship operator, right? Until the limits of liability of the ship are met. But then if the damage from this module goes over the limit for the ship, then the claims, this module is treated as installation, and then the claims go to the permittee, lessee of the area in which the module operates. We talked about this limitation of liability, that it is much more easy to break limitation of liability under OPA than under LLMC or CLC, etc. But why? Well, first of all, the test is not only willful misconduct, but also gross negligence, but also, stay with me, hold on, violation of federal safety, construction, or operating regulation by, and now, responsible party, employee, agent, or contractor of the responsible party. So not only the test is really broad, but then also the act doesn't have to be personally done by the responsible party, right? And even more so, there is also the idea, I don't have it on the board, that if the responsible party doesn't cooperate with the Coast Guard, they lose limitation of liability. So while under international conventions, this limitation of liability is a right, here this is a privilege easily floating away from the parties. Okay, and I think we're going to move on for the sake of the break. I have a few slides on those industry agreements, OPAL being the industry agreement, but I think I'm going to move further. And with that, we're going to go back to the IMO-LEC. So we had this proposal in London, 2009, Indonesia. How about we're going to come up with the International Convention on liability for offshore rigs pollution. The same countries, that was something I think interesting in terms of diplomacy at the IMO, because it seems that the same countries that supported in 2009, the first meeting, the Indonesian proposal, then at the level of the Council Assembly, they said, right now we're not that convinced, let's take it back to the IMO-LEC to discuss it again. And then this idea was basically crashed. We had, although CMI presented a paper, maybe some of you participated, I did, in this questionnaire. We had a questionnaire then about our national laws on liability from installations, and the report was, well, maybe we should, in fact, look into that. That was what the CMI said, but the industry was against. Like, there was a clear message from the industry, they're not interested, that it's better done by the bilateral agreements, regional agreements, or industry voluntary schemes. And this idea of creating new conventions died, but there was some compromise made. Instead of working on international convention, Indonesia was tasked with preparing guidelines, non-binding instrument. And these guidelines have actually been developed. You can have a look on them, they are available. These guidelines, their aim is to aid national states, national legislation in formulating either their own acts or bilateral or regional agreements. So it talks about what should be discussed in such a legal act. And it may be treated as an inspiration, right? So this is what we have. And if we think about it, there are advantages, pros and cons of having international convention and not having. I have some ideas, probably you have more than I do. The idea for the advantage of this uniform act would be, surprisingly, greater uniformity. Maybe it would bring more predictability, which could be transferred into lesser risk, and then the investment would be more reliable, I'm thinking. And of course, such an international treaty would most likely provide greater compensation. But there are disadvantages as well. As far as I'm concerned, as far as I know, there is nothing like PMI class when it comes to the insurance, right? So what insurance would there be on the market? Whether we would be able to find reliable insurance. Even now, LEC deals with the problem, we deal with the problem of unreliable insurance for tankers under CLC. We discussed that, right? And even more so probably with the installations. What would be the agreeable limit of liability? Right? If you look at the Deepwater Horizon, the BP probably under political pressure and social pressure, said that they are not going even to try to limit liability, right? So they created a fund of $2 billion, like huge funds to compensate the victims. I mean, if states like United States have something like this on the table, why they would be agreeing to other lower limits of liability? There is this administrative burden, and of course, as we know, conventions take time. This is time-consuming process. And unfortunately, we've been facing for the last times something what we can maybe call a crisis of international conventions. And the thing that we would definitely not like to have is another convention which was drafted but not adopted. And with the last slide, I have something for our younger friends prepared especially, but everybody could do that if you want. It's fun. It's anonymous. You can go, I want you to vote. There is a question and you choose one of the three answers. You can go on your phones to a web page which is called menti.com, and then it will ask you for this code, which you have. Or you can take a photo of this QR code and it will take you directly without the code to the question. And I'm going to right now go to that web page to see how you're all doing. Hold on, I have to present that, so give me a second. Well,
what was the code number?
I will bring it back in a second, Igor, but let me open that. Okay, this one I present. And you asked me about the code number, and the code number is 2536 2632. And let's see what are the answers. Oh, we have many people. We have nine persons joining. Okay, so that's interesting. No, I'm not taking that one. You were not supposed to pick this one. No way. People, clearly. Interesting. I was actually thinking that no would be more eagerly chosen. Well, then you all contact your representations at the IMO and talk with them, your permanent representatives, and bring that subject again to the attention of the IMO. And with that,
we'll make a screenshot and send this to IMO. They're animal lovers and they will accept it. Often they're arts.
thank you so much.
Thank you.